The case of Adajar versus RWR Homes Incorporated reminds us all that in order to force someone to arbitrate a dispute, you have to be able to prove the existence of that arbitration agreement. Now in this case, the homeowners sued their developer for construction defects, and the developer moved to compel arbitration. Now the developer argued that the owners had agreed to arbitrate construction defect lawsuits. The defendant produced a standard form application for warranties that it gave all the homeowners and evidence that the homeowners signed that identical form. Now the standard form contained language supposedly confirming that the homeowners had viewed a video and read a sample warranty booklet and that they were consenting to the terms of a binding arbitration provision contained in that video and the sample warranty booklet. Well, the trouble was the defendants neglected to introduce any evidence of the actual sample warranty booklet or the video, and instead submitted copies of conflicting versions of actual warranty booklets that were issued after the fact. Well, to top it all off, almost all of these homeowners submitted declarations that they had not received the video and had not been given the sample booklet. Well, the trial court denied the motion to compel arbitration, and the Court of Appeals affirmed that decision. Acknowledging the long-standing policy favoring arbitration, the crux of the court's holding was that arbitration can't be compelled absent an agreement. Now, by failing to provide evidence of the video or the booklet, the terms of the arbitration to which these plaintiffs supposedly agreed couldn't possibly be determined. The defendant had supplied other warranty booklets, but those contained different arbitration clauses, and thus it was not known whether which, if either, resembled the actual clause contained in this sample booklet that was never produced. The court rejected the defendant's argument that because the plaintiffs had signed the application acknowledging having seen the video and having read the booklet, the plaintiffs had the burden to show that they didn't know or willingly agree to the incorporated arbitration provisions. Well, the problem here was, again, the defendants didn't put on evidence of what those supposed arbitration terms were, and it was the defendant's burden to prove the arbitration contract. So, the lesson here is that if you want to compel arbitration, you need to be sure to be able to lay your hands on the actual arbitration agreement that was agreed to, and then make sure you get it in evidence.